Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Hello, everyone. Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II, principal of Carter Arnett in Dallas. Robert has more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas and federal courts nationwide. I'm Sean O'Connor, and today we're discussing how patent cases are defended in the Eastern District of Texas and what strategy looks like on today's docket. Bob, good to see you.
Good to see you.
Let's get into this. You know, the Eastern District of Texas has it's long been associated with patent litigation, and as a sidebar, I'm wondering why that is historically, and then how would you describe the current landscape for defendants that are appearing there today?
All right. Well, historically, it really started back in the mid '90s, where Texas Instruments, which is a very large technology company focused a lot on high-end semiconductors, and they have facilities both in the Northern District of Texas and the Eastern District of Texas, and they were a little frustrated by when they were enforcing their patent portfolio, bringing patent infringement cases with the amount of time that it would take to get a case to trial. And so they brought a couple cases in the Eastern District because they knew that, that district is, historically has moved cases along pretty quickly. It doesn't really have any big urban centers. I guess, Texarkana or Beaumont are probably the biggest cities, and they're like around 100,000 people. So they had success. They got to trial pretty quickly, and they had jurors that, were not afraid to enforce property rights and award big verdicts. And people took notice and started filing more cases there. And then in 1999, a judge named T. John Ward was appointed to the bench sitting in Marshall, and he got together with the other judges, and they created a set of local patent rules that provided some timetables and procedures to help move the patent cases along. And it became known that the judges in the Eastern District were welcoming of patent cases. A lot of judges around the country don't like them because there's additional procedures that are involved. Oftentimes the subject matter is scientific or complicated, complex, difficult to deal with. And patent cases in some places tend to languish. They don't get resolved quickly. And, people started filing, plaintiffs started filing patent infringement cases in the Eastern District and had a lot of success. And it's sort of remained that way ever since. There have been a number of years that the Eastern District of Texas, although it's a relatively small district in terms of the population that it covers, it has been the number one docket for patent infringement cases in the country. In other words, the district where more patent cases are filed than any other. So, sorry for the long answer, but it's that's the thumbnail sketch of the history of it.
Oh, that's great background. It's interesting that essentially an expertise was developed and made it easier for the judges to navigate those complex cases, and obviously there's lots of benefits to that.
Right. So to address the second part of your question, which was, what's the landscape like now?
Oh yeah.
I think the landscape is fine for defendants. You have a number of judges who are, very familiar with the procedures in patent infringement cases. Understand that that you need to move them along. You need to make decisions. There's a magistrate judge named Roy Payne who sits in the Marshall Division, who has done more Markmans than anybody ever. rendering those decisions. And so you have the expertise there. Um, you know, uh, the Eastern District is not really as, plaintiff friendly or defendant, opposed to defendants as some people, uh, put on. It's I think there is an inclination to allow cases to go to trial. That may be viewed as being pro plaintiff, but really it's really pro jury. Letting a jury decide a case.
Yeah.
And defendants have had success in the Eastern District as well. So it's not it's the landscape is not as dismal as some defendants let on. I know that I served as a member of the board of directors of a technology trade association, and there were people, other members who uh, told me that they did not want to put a facility uh, anywhere in the Eastern District of Texas because they didn't want to be subject to patent infringement litigation there. And despite my best efforts to assure them that it really wasn't as dire as they're letting on, they were stuck with their preconceptions.
Yeah, that happens. That happens. Speak to the Supreme Court's venue decisions, right? I mean, that reshaped patent cases, where they can be filed. How has that, or how has the character of the docket evolved in the wake of that?
I don't know that it's really had a terribly significant effect early on. So the big change was it used to be that um, you as a plaintiff filing a patent infringement case, you could file in any district where the defendant had committed an act of infringement. In other words, sold an infringing product. And so, if you're a national or a worldwide company, that basically subjects you to, like a Microsoft or an Apple,
Yeah.
that subjects you to venue anywhere.
Yeah.
So the Supreme Court interpreted and reversed some longstanding law by the Federal Circuit about the patent infringement venue statute, and so no, what it means is either where the defendant has uh, their principal place of business, or they have where they're incorporated, or where they have a regular and established place of business. So then there was a period of time when there was litigation over exactly what that meant. I mean, did that mean brick and mortar facilities? Exactly what did that mean? And so I think uh, the judges in the Eastern District, the district judges, got mandamus to the Federal Circuit several times, and the Federal Circuit had a more stricter interpretation of what that meant, such that motions to transfer venue that had been denied were sent back down with instructions to grant them. And then I think two things happened. One is the district judges became they followed the guidance from the Federal Circuit and started transferring cases more, and plaintiffs started taking a harder look at do we really think that we can keep venue here, or are we just buying ourselves the work and effort and expense associated with filing a case here and then getting it transferred to the Northern District of California, for example. So I think it did change it a bit in that circumstance, but you know, it's really not that significant, I think.
Got it. When a company is served with a patent complaint in the Eastern District, what would your advice be in terms of strategic decisions, that they must make immediately?
Well, number one, hire local counsel. That's important. Hire a good local counsel. Uh, and number two, you really need to assess, you know, there are a number of considerations. Do you want to push for an early Markman hearing, for example? If you think that you've got a much better read on the the claims of the patent than the plaintiff is depending on in terms of getting their infringement read, then you probably want to have an early Markman, and you want to have an accelerated timetable for that, because that can lead to, either potentially more favorable settlement or perhaps summary judgment practice and get some claims thrown out, or the case thrown out entirely on summary judgment. So it requires a lot of upfront analysis of the patent, of the I guess the other factor would be, do you think you've really got a good case for holding the patent invalid, for invalidating the patent? And do you want to push that hard? So it really, you need to get good local counsel, and then you need to spend the time and the money to really do the analysis early in the case, rather than just kind of letting it play out until you absolutely have to do something.
Okay. So another question would be, how do scheduling orders and case timelines in that court influence defense preparation and resource allocation? You alluded to that somewhat, but can you say more about that?
Sure. So, I mean, fairly early on in the case, you have a scheduling conference, and typically the questions are, will you consent to trial before a magistrate judge? And the district judges encourage people to do that. And in the Eastern District, that's not a bad option. I mean, although district judges are appointed by the president with the advice and consent of the Senate, magistrate judges are basically hired. They have 8-year terms. Now they're vetted as well, but it's not at the same level. And so in many cases, people think, you're getting a junior league judge if you get a magistrate judge. But in the Eastern District, you've got some very fine magistrate judges, and on whom the district judges rely a lot. So the benefit to consenting to a trial in front of the magistrate is you have a hard trial date, and you're going to go to trial on the date that is assigned. Whereas with the district judges, because they also handle criminal cases, and criminal cases can bump a civil case if there's speedy trial concerns. So you may not go when you're set. So that's one question, and then basically there's a standard scheduling order that comes out, and you fill in the dates and send it back in, and the judge, the scheduling conference will give you a trial date. And then you fill in the dates, you back them off. If you can't agree, then you go back to the court, and the judge decides for you what your pretrial deadlines are. But there are a lot in a patent infringement case, because there's deadlines to submit your infringement contentions. In other words, the plaintiff's contentions about how the accused products infringe the patent, and the defendants have responsive deadlines. Defendants have deadlines to provide their invalidity contentions. In other words, here is the prior art, earlier patents or earlier inventions that were published that we think render the patent either obvious or anticipated, or there's some other reason why it's invalid. So, and then you've got the identification of what terms each side thinks need to be construed by the court. And that's part of the Markman process. And then there's briefing on that. And then more recently, there have been fewer hearings. It used to be that there would be fairly lengthy Markman hearings. You might even present expert testimony live at a Markman hearing, but that's the trend has been away from long hearings on Markmans. So the briefing becomes more important. Each side gets to brief how they think a claim ought to be construed, and then and sometimes the judge will want to have a technical expert who's essentially the court's expert, although the parties pay for the technical expert's fees. The technical expert's not really beholden to one or the other. He or she is reporting to the district judge. So all those things have to be worked in a schedule, and hopefully you're looking at a trial date that's maybe 2 years out, 18, on the early side, 18 months, probably mid-range, 2 years.
Claim construction remains a pivotal phase in patent cases. How does early Markman strategy affect leverage for defendants?
Well, I alluded to that a little bit earlier, but if it depends on whether you think that you've got a better read on the claim terms than the plaintiff does, or that you have a higher likelihood of getting a favorable decision from the district judge, or or the magistrate who's going to take the first crack at it. And so if that's the case, you would want to have an early Markman, because it sets the ground rules, and that may lead to an earlier resolution of the case, either by way of summary judgment or perhaps settlement.
Okay. Well, and you mentioned summary judgment. I'm curious, from a defense standpoint, how does summary judgment practice in pretrial motions differ in the Eastern District compared to other venues? Is there a difference?
I don't think there's a big difference. There is a perception that the judges in the Eastern District are less likely to grant summary judgment motions than in other districts, and there may be some basis for that if you look at the statistics, but it's not. I mean, it's not the case that it's a lost cause to file a summary judgment motion in the Eastern District. Certainly, if it's a well-grounded motion, and pretty clear-cut issue, that you'll get summary judgment as a defendant. So, that's basically my summation on it.
Yeah. I mean, you're talking about perception of the district, and certain companies, or wouldn't want to be located there and deal with the systems there. I'm curious, the jury dynamics in the district, they're widely discussed. How should defendants think about trial presentation and narrative framing when they find themselves there?
Well, number one, you should hire a good local counsel. Number two, whether it be your local counsel or a member of your trial team, you need to have a good trial lawyer who knows how to talk to jurors. Some mistakes that some defendants made, at least in the early days of when the Eastern District became a hotbed for patent infringement litigation, was they would have patent lawyers trying the cases, and very bright people, but not really able to connect very well with regular everyday folks who are going to sit on a jury. So you need you're better off served if you have that local touch, as well as somebody who knows how to talk to the regular folks who are going to sit on a jury without condescending to them. Another mistake that occasionally gets made is talking down to the jurors, like they're
Right.
A bunch of yahoos or yokels.
Yeah.
My partner Leon Carter said, because he's from the Eastern, he's from Carthage, Texas.
Yeah, he's
So
one
he's
of the,
got-
he's one of the local yokels.
Yeah, so he says they think we're a bunch of yahoos.
Yeah, and I'm sure he's like, they're not wrong, but not all of us. We're out of time. We'll talk more about this and other topics going forward, Bob, but great to see you.
Well, great to see you, and enjoyed the conversation.
Same. Well, that's it for today's episode of the Texas Commercial Litigation Podcast with J. Robert Arnett II of Carter Arnett. To learn more about Bob and his firm's work in business and intellectual property litigation, visit their website, carterarnett.com. As always, thanks for listening, and remember to like, subscribe, and leave a review if you found this episode helpful. I'm Sean O'Connor. Have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.